schedule. Commissioner Gorelick.
Thank you, Mr. Chairman. I'll try to be brief. Mr. Thompson, as you know, I sat in your shoes at one point when you were deputy, and I was deputy before that. And I have a very...
I tried to follow your shoes.
Oh, thank you. Flattery will get you nowhere. I would like to ask you a philosophical question about the role of the Department of Justice. As you know, it has two basic roles. One is investigative and prosecution in this context, and the other is the protection of rights. And post 9/11, it seems to me that there has been enormous pressure on the institution to favor the first role just because of how terrible an event 9/11 was. And so my question to you is, who speaks for civil rights and civil liberties and that perspective within the councils of government? And this question was brought to mind when I appeared on a panel that I know you were on the same program on the Third Circuit, where the former head of the Office of Legal Policy and the former head of the Criminal Division essentially said that the government's position with regard to taking American citizens and holding them incommunicado without lawyers and with no opportunity to challenge whether they were properly being held as enemy combatants was unsustainable. One of the gentlemen, Viet Din, said it was unsustainable. The other, Mike Chertoff, said we need a new system to make sure that there are checks and balances. So I have a two-part question. The first is, were you so advised when you were deputy, and who spoke when we as a government were creating the architecture that put people incommunicado without counsel, without ability to challenge the circumstances under which they were being held? Who spoke for our rights when that system was being set up, and do we need a new structure to have that voice be heard?
Commissioner, at that conference, the Third Circuit conference, I quoted from a decision of the Supreme Court of Israel that I kept on my desk for the past 2.5 years. Shortly after the events of 9/11, I was visited by Justice Barak from the Supreme Court of Israel. He wanted to see the Attorney General, but the Attorney General was traveling, and he saw me. And he left with me a decision of the Supreme Court of Israel that dealt with the interrogation of terrorist suspects and the use of what was called their moderate physical pressure in the interrogation of terrorist suspects. And I don't really know technically what moderate physical pressure is, but it's something
imagine.
Beyond questioning, just simple questioning.
I can imagine what that is.
And the Supreme Court of Israel prohibited that activity, and in some very eloquent words, and I think my old speeches are online at the Department of Justice, but I quoted from that speech throughout my tenure as Deputy Attorney General, and I referred to that speech in not only the Department of Justice internal deliberations, but in interagency deliberations. And the gist of that is that we're a democracy. We have to abide by the rule of law, and that not all means that are available to protect a democracy sometimes can be utilized. And sometimes the democracy, while it looks like we have to fight with one hand tied behind our back, we have to do so if we're going to preserve our basic values. So to answer your question, I tried to, and I know other officials always thought about these very important civil liberty concerns. We would be making a terrible mistake as a country, and certainly as a Department of Justice, if we allowed what happened on 9/11 to change the essential character of our country. I don't believe that has happened. We certainly have differences of opinion as to how we should have reacted, and some of the ways that we are trying to proceed in combating terrorism. But I don't believe that we have retracted from those. For example, when we undertook the revisions of the Attorney General investigative guidelines, it was always of paramount concern to myself, and I know it was of concern to the Attorney General, that nothing in there give rise to any belief, and that's why we specifically stated it in black and white, that agent should undertake any kind of investigation of activities that are designed, that are protected by the First Amendment or other laws. Enemy combatant situation, I'm really not punting, but that was a matter that I was involved in as a lawyer. I don't believe, and it's still in litigation, so Commissioner, I don't believe it would be appropriate for me to make any kind of extensive comments on a matter that's in litigation and in a matter that I was deeply involved in as a lawyer.
Well, we will, with all due respect to that position, I think we will need to return to it as a factual matter and
understand.
determine how those decisions got made. One of the things that's been striking across the panels that we've had on every subject is that you get an amazing amount of candor from people once they take their respective uniforms off. And to hear two former Justice Department officials say that a position that was taken by the department essentially was unsustainable, is unsustainable, and to hear that now is disturbing and leads me to wonder whether we have the right checks and balances in place, or whether we have put so much pressure on the Department of Justice to be the investigator that we perhaps need a countervailing voice, a counterpoint, some independent body to be the voice of civil rights and civil liberties. And I'd be happy to give you the last word here. Had I had time, I would have returned to that theme with respect to the Foreign Intelligence Surveillance Act, because I believed when I was at Justice that I had enormous power that was essentially unchecked. And of course, with the changes in the Patriot Act, there's even greater power in the Department of Justice, and I really do wonder whether there are sufficient checks. But I know I should give you the last word, and then I know there are other commissioners who would like to have an opportunity to give a question or two.
I believe Judge Chertoff's comments will speak for themselves, but as I understood what he said was that a lot of decisions were made in the context of a crisis, and people were making the very best calls that they could, and that with respect to procedures in terms of granting access to counsel, that perhaps we should review and revisit some of the thinking with respect to those procedures. I think that's what he said, which is a little narrower than.
Well, it's a matter of public record, and,
Sure.
and we don't have time to pursue it now. But
I
I do
hope you understand my
appreciate
comment
that there
on it.
were urgencies of the moment, and that's one of the purposes of this commission is to step back from those urgent moments and take a look at whether we have the right structures in place going forward. Thank you very much for your testimony, for both of you.